this matter, 2 weeks ago when I was here with the same panel, save for Senior Piakubi, when we were joined by Gary, I said this is a matter that is snowballing out of control. It is snowballing out of control. Look, this is what we call voir dire in law. This is a trial within a trial. We are dealing with a matter that arose in the course of a hearing. And I think that the court has a duty to determine that matter before it proceeds. What is happening? We are dealing with an evidence. And our Evidence Act is very clear. It defines evidence as a testimony, writing, material, objects, or other things presented to the senses that are offered to prove the existence or non-existence of a fact. All right? So what Jakpa has adduced in court is to prove the fact that he is alleging the occurrence of a certain event, which one goes to the commission of a crime as well as leads to the commission of a professional misconduct. Now he's testifying to those matters. Others are arguing whether a telephone recording can be admitted in a court such as this. It is. In fact, there are two legs to dealing with this matter. There are two doctrines. We have the inclusionary doctrine, which doctrine was laid down by Justice Crompton in the famous case of R versus Littam in 1861, Cox 8 criminal case 98. What did the judge say? The judge said, it matters not how you get this evidence. It doesn't even matter whether you stole it. It will be admissible in evidence, and the probative value placed in it. So this subsequently became the inclusionary doctrine in our criminal jurisprudence. That is why when you look at our Evidence Act in Section 51, they say relevant evidence is admissible. But when it comes to 52, it talks about the exclusionary rule. What does the exclusionary rule say? It says that evidence, though relevant, will be inadmissible if its relevance is far outweighed by its probative value and will prejudice the case. Now, this doctrine was also set up by Lord Diplock, all right? In the famous case of Harvard, the trial judge in a criminal case has always a discretion to refuse to admit evidence if, in his opinion, its prejudicial effect outweighs its probative value. And that is referable to our Section 52 of the law. That is the exclusionary rule. Yebo Adami will go down in our legal history as an attorney general that will become a vicious enforcer of vigilante justice in this country.
How do you talk about vigilante justice?
Yes, vigilante justice, because you see, this is an attorney general who is able to enter a nolle prosequi in respect of some hoodlums who stormed our courts in Kumasi. He couldn't prosecute.
My brother,
hold on.
I thought he went to.
Hold on.
I thought he went to.
Hold on. Why?
It was the attorney general.
Why do you deputize for an attorney general?
Okay.
Do you know who entered the nolle prosequi? Let me make my case. He should have resigned when that was done if he's not associated with it.
So
I am saying that they find it prudent to let some hoodlums who even storm our court and scandalize our court to walk. That this attorney general is in court prosecuting my former party chairman upon an allegation of a leaked tape. Do you understand what I'm saying? He accuses my former chairman Ofosu Ampofu, of having committed some crimes supposedly contained on a leaked tape from a meeting he had. This attorney general is in court prosecuting him. And when there's an allegation of commission of a crime contained on a leaked tape, even where a court of law is asking you to recuse yourself, you have the F-1 to tell us that you will.
Please,
let me say this. When you go to a court of law and the court says, I am advising the parties to stay away from the subject matter of the litigation until the final determination of this case, it has a judicial value.
You said she strongly advised.
It is as good as an injunction.
That advice.
Hold on. You are technically injuncted. The court is saying that I am advising the parties to stay away from entering the land. Hold on. Listen, I am saying the court.
I want to get.
Hold on. I am saying
how
when
an advice becomes technically.
The court is not in the business of advising parties. That's even lawyers. The court doesn't advise lawyers. So let's get these principles clear. That the directive given by the court is an advice. The court, they rule, they order, they direct.
No.
I am saying that the court gave a directive.
That you think.
I'm not thinking. This is a judicial pronouncement.
Okay.
And a judicial pronouncement.
You see, this is a difference.
Alfred,
in
I have listened
meaning.
quietly, so allow me to make my point.
I'll allow you to make your point. When you are
people should learn. So people should stop saying the court gave a directive.
That you think.
I'm not thinking. This is a judicial pronouncement.
Okay.
And a judicial pronouncement.
You see, this is a difference.
Alfred,
in
have listened.
meaning. You say that a strongly worded advice.
You've made the point. So let me respond.
It's tantamount to what?
You are killing my time, Alfred.
No, I'll give you your time. I'm asking you the questions. You understand?
So and I'm answering you.
Proceed. Yes.
I'm answering. I'm saying on authority that this is an injunction. That is an order directing that and continue prosecuting that case. One, he will lose respect from the court, refuse not to hear him because the court has advised him strongly to stay away from the case. So it amounts to an injunction. And I will defend this anywhere. Okay. So if the Attorney General would disregard this directive from the court and go back to the court, it is to his own career and it is to his own integrity. But the point I am making is that even the judge,
which proceedings
of the court,
which day?
Go to page 22. The proceedings of 13th day. Something there. Even the trial judge has been incriminated.
Maybe while the judge is can you just read?
Yes.
Read.
Now paragraph 2 portion says, okay, let me read. Something there. Even the trial judge has been incriminated.
Maybe while the
Attorney General jumped in and said, my brother, you know I do not run the office alone. If you cannot fulfill your promise to me in your own office, how can you guarantee that I can be acquitted at the final judgment since you cannot control your own staff in your office? How can you control the judge? If she decides to bang me in, then I will have to be appealing from Insawam. Then he said, everything has been arranged and that.
Yeah,
what does that mean?
Wow. No, but
AG has promised him that he has already. Did you listen to the statement?
No, so that portion. That
is what we are. Okay. So who is going to recant this? Okay. How are you going? If you won't mount the. So these are matters that are going to the record. Be mad. It's copiously referenced in the proceedings. His safety in the matter. And you think that this shouldn't worry you as officer? It bothers me. No, I'm not inviting you. I am putting it.
Okay,
this political trial is scandalizing the country, scandalizing the judiciary.
Let them go to the trial.
I am saying that he's making an allegation against an attorney general, city attorney general, that he has told him that he has an arrangement with the judge regarding his safety in the matter. And you think that this can... He's making an allegation against an attorney general. City matter will have to be halted and proper investigations conducted. Anyway. It is my opinion. Yes. It's an opinion founded on matters of law and of fact. So matter will have to be halted and proper investigations. The Boadami must be investigated as a public officer. All right?
No. Let's go up here. Hold on. He said then the Attorney General jumped in and said, my brother, you and I know I do not run the office alone.
Yes.
When they submitted their position against the submission of no case, I could not say no because I do not work alone. at the office of the Attorney General.
Do you see the part even saying he gave AG documents before the establishment of no case came?
After I had given him documents, he demanded from me and did not honor his part of the bargain.
Yes.
Then
says, come to the judge.
And then he goes on and says, I could not say no because I do not work alone, that I can be acquitted at the final judgment since you cannot control your own staff in your office. How can you control the judge if she decides to bang me in? Then I will have to be appealing from and so on. Then he said everything has been arranged and that I should not worry about that. Then I said no.
Is this on the tape?
I will fight you.
Is this on the tape?
No, this is his
testimony
before court.
Yeah,
this is the true and certified copy. And the judiciary
it's even more valuable.
No, it says, then I said no, I will fight you and the judiciary to the last. No, it says, then I said no, I will fight you and the judiciary to the last drop of my blood.
He's being cross-examined.
Yes,
so I was getting angry because they had betrayed me.
Yes. And this is evidence so what is adducing under cross-examination.
What has been the questions on this?
Which questions?
Because
that is why I have issued a statement regarding the allegations of the involvement of Justice Yoni Kuleni in the matter. If the office is minded, if they are not minded, the further proceedings of this case, the witness is even implicating the judge. Since of his prosecutor that he already has an arrangement in place with the judge regarding him. That is also a matter arising. And I'm saying that the court, like Pebu says, the court is further being scandalized. And it will be proper for this matter to be discontinued. Because
allowed to make certain comments when you are invited. That I would allow because he invites you. If you have any point of departure, to the extent that we haven't concluded on this topic, I will...
That having been said, the doctrine that our courts will not admit recorded telephone conversations is also not entirely correct. The court agreed that in the case of Abna Pukua and ADB, the court said the recorded conversation between the woman and the customer that led to the revelation on some confidential information was an abuse of a constitutional right to privacy. But in the Kugbaji case, all right, that was Doche in Abna Pukua. But in the Kugbaji case, Puamai agrees that that principle cannot be Abna Pukua distinguished, especially in respect of the nature of the offense, the nature of the right, the nature of the matter in issue. So if you are recorded and the recording is in respect of you participating in a crime, you are planning to commit a crime, the court will admit it for its probative value. Because you cannot be excused from and walk free. That is why even in some cases of some crimes, the mere thought of it amounts to a crime. You are aware?
Yeah.
You know. The fact that you think about it, which in the ordinary circumstances ought not to constitute or form a crime, a charge will be formed for thinking about, for instance, to overthrow the republic. So it is important that even, for instance, when you threaten somebody, you must have just threatened the person without carrying out the act, but it constitutes a crime. So the court is very clear that the nature of the offense or the nature of the trial or the case before the court will determine whether or not the recorded electronic evidence will be admitted. That is the Kugbaji one. So in this case, the recorded evidence is that the Attorney General is engaged in the commission of a crime himself and also engaged in a professional misconduct. That is why the court admitted this evidence and will place the probative value that he ought to place on it and determine this matter. This matter it's become so scandalous, it's so stinky that the Republic, look, this prosecution is done on behalf of you and I. Yeah. We are no longer interested because the scandalous matters that are arising from it will serve you and I's interest. Right. And I think I will support Martin Pebu that the Attorney General or the state should enter another process so that we can all go to sleep. But it doesn't mean that other remediable actions available to parties who have been injured, who have been damaged, who are aggrieved in this case cannot be taken.
Okay.
Against the Attorney General, for instance.
Well, thank you. And it's some 12 minutes after 10.